Any mention?
May it please your lordship. My lord, I am troubling your lordship. One FIR has been registered against state DGP, your lordship. Your lordship may take up this matter today, my lord. Very urgent, my lord. Lots of humiliation, my lord, is facing. Yesterday, in fact, it was mentioned, but it was over. Time was over. As the last item, I will try my luck, your lordship.
You filed it already?
Already, my lord. It is numbered also. Today, my lord.
Okay, we'll just see.
Deeply obliged.
Please, Your Lordship, I beg to mention item number 9, Lordship. I pray for 2 weeks' time, Lordship. This was heard on the last occasion, Lordship.
Yes.
Yes, Lordship. I'm appearing on behalf of Mr. Ayub Khan, Lordship. I pray for 2 weeks' time.
Yes, Mr.
No.
When do you want it?
2 weeks, Lordship.
2 weeks on the request. Yes.
Much obliged.
May it please your lordship. Your lordship, I beg to mention item number 14.
Yes.
We are for the respondent number 3 and 4, your lordship.
So I'm from petitioner, Your Lordship.
Yes.
The conducting counsel is having some personal difficulties, your lordship.
Objection.
When?
2 weeks, your lordship.
Listen. 2 weeks on the request of the respondent, private respondent, isn't it?
Yes, your lordship.
Private respondent number?
3 and 4.
Who is for the state? No one is there for the state.
Karmi, Lordship.
Yes, Mr. Abraham. Yes.
No objection, Your Lordship.
Yes.
Highly obliged. Good day.
Please, Lordship. I beg to make a mention of item 13, Lordship, on behalf of Ms. Sarda Tai, Lordship.
Yes.
I pray the matter may.
State, who is the state? Have you informed the state? Is this a matter which was there last week and she wanted to 1 week's pass over? This is, you see, like, you do not know what is the logic behind taking, you see, time in.
I've been instructed, Lordship.
You see, like 1 week. If you want adjournment, you take in 1 shot and then next day you do it.
Lordship, let the matter call up, Lordship. She'll be here.
When do you want it?
2 weeks, Lordship.
Say, Mr. So-and-so, appearing we have of Ms. Ardhya London Legal Aid Council. Praise for adjournment of the matter by 2 weeks.
No objection.
Highly obliged.
The state has no objection. Prayer allowed. District for 2 weeks. Yes.
Please, Your Lordship, I beg to mention item 6. Item 6.
Item
6.
6. Say loudly. Yes.
Lordship, we have already informed the respondent.
You have already informed, but this is a 2017 matter.
Lordship, I'm praying for some accommodation for today as the Senior Counsel is engaged in one hearing matter in court room
Just
number 1.
been informed some time back, Your Lordship. 2017 matter, Your Lordship, whether they're still interested in pursuing the matter also, because, Your Lordship, I have some latest instructions is that few of the writ petitioners also have they wanted to withdraw now.
Is it?
The 14 of them.
How do you know it?
No, because I am the chief. So those villagers who are, they have written a letter to me saying that.
Tell them to file an appropriate application.
That will do it in course of time. But I'm not concerned about the merits of the case.
It cannot be after conclusion of the final hearing, isn't it?
Cannot be. I'm just making my submission, or else I'm ready for a hearing anytime.
Otherwise, also, Mr. This is 2017 matter.
Yeah.
See, unnecessary. Why should this matter be kept pending? And the repeated adjournment, prayer of adjournment, shows that the petitioner is not at all interested in legal matters. It is just matter is kept alive just for the sake of keeping it alive. That is.
Otherwise, everything is settled now. To unsettle everything for the past, what has happened the past 8 years, and many enactments have been passed also.
You are paying for the district council, so you are opposing the prayer. Yes, when you want.
1 week, Your Lordship.
Hmm?
1 week.
1 week has
1 week, Your
been
Lordship.
for the past 4 weeks. Every week has been listed, Your Lordship.
Yes, why you do that?
Ask for a definite time so that the matter may be heard and finally disposed of.
That is what you do. That is what you do. Instead of seeking time like that, 1 week out. So you'll do it next week. We'll remember it. The next week you will not get any time. Just say on the request of the petitioner, list after a week.
Lordship, similar prayer for item 11. Similar prayer for item 11.
Speak loudly. Cannot hear. Item number
11.
11. Yes.
No objection.
No objection. You are appearing there, sir?
Yes, Your Lordship. I'm for respondent number 5.
Prayer for adjournment has been made. 11. Adjourn of the request of the petitioner by 2 weeks.
Yes, Lordship.
Yes.
Value pledge.
Item number 1.
Yes.
Lordship, in this matter, similar matters pending before the division bench, Lordship.
The connected matter. The Learned Counsel for the petitioner submits that the connected matter pending before the division bench is yet to be dismissed. He has to be disposed of. And prays for adjournment of the matter. When?
Lordship,
That
the
is
matter
hard.
fixed.
The division bench matter has been hard or not?
Not yet, Lordship. They have not fixed their date yet as of now, Lordship.
Not yet.
Not yet fixed, Lordship.
Just say. Release this matter after 3 weeks.
Value pledge.
Prays for an adjournment. Then
Item number 2.
Please, Lordship. Pray this matter may come at the end of the board, Lordship.
at the end of the board.
Yes, Lordship.
How many matters we have in the board? At the end of the board?
Yes, Your Lordship.
Yes.
Item number 3.
May it please you.
On the
Yes.
last day, the petitioner had prayed for some time to peruse the objection that we have filed.
I'm praying for some time to seek instructions, my lord.
What instruction?
Instructions from the client.
You have not contacted the client after you received the objection.
We have contacted Your Honor. We are awaiting instructions.
Yes.
My lord, one more chance may be given.
Only one more chance. Right now
My
we
lord,
can give.
it's an objection. It's for instructions. They are not saying whether they want to file a rejoinder or what. So for
Right
instructions,
now
one
we
more
can give
chance
them
may
only
be
one
given.
chance. We cannot give them 2 chances at a time.
My lord.
And my lord, the interim stay may kindly be extended.
My lord, that was already
That is
until
already
further
there. Is until
orders.
further order. See the last order. Okay, Mr. Since we are appearing for the petitioner. 6. Grant of some time for obtaining instruction. from the petitioner. Prayer allowed. List after 2 weeks. 2 weeks.
Highly obliged.
3, 4, and 5 are similar matters, my lord. They are connected.
Connected matters.
Same parties?
Yes.
Same lawyers?
Yes, my lord.
Yes, my lord.
Same set of lawyers, lordship.
Yes. Okay, 3, 4, same order.
Highly obliged.
Hearing item
Obliged, lordship.
Yes.
I'm praying, my lord, this matter also can be taken at the bottom of the list, my lord.
Under the board.
My lord.
There's hardly a meter left for under the board. There's already one over matter passed over.
My apology, my lord.
You can start the matter. What's the problem here?
Actually, my other colleague is, my lord, my other colleague is following up the matter, my lord. I'm not well acquainted with the facts, my lord.
This is a problem, you see.
I'm extremely sorry, my
An
lord.
adjourning matter because of non-availability of lawyers. You see, it becomes very difficult.
Absolutely, sir.
If you have to accommodate all the lawyers, then the court will revenge
Absolutely,
us.
I completely agree, my lord. My apology, my lord.
When you work in a group, at least you should distribute the work in such a way so that no work gets disturbed.
Lordship, lordship.
Okay, at the end, call it at the end. Just see if they can. Just see. Allow me to.
Item number 8.
Yes.
May please, Lordship. Lordship, I pray this matter may be taken up at the end of the board.
How many hands do you have?
My lord.
That is a matter probably.
Lordship,
earlier occasion submission was made.
Lordship.
Yes, Mr. Paul.
Lordship, the matter was.
Yes.
Lordship, this matter may be passed over, Lordship, because the learner additional advocate general is dealing this matter, Lordship.
On the last occasion, we
The
had some
learner
suggestions.
additional advocate general, Lordship, Mr. N.D. Shulai is dealing this matter, Lordship, and he's stuck in the DB.
This is a problem, you see. When senior counsel is not available, you are there, and then when he is there, then others is not.
Number 7 also we had paid for the.
Yes, Mr. Paul.
Well, it's
What is to be done?
this. I
Shall we
think
wait for this matter to be taken up today? Or
but what, my lords, I think what was following from my lordships is there was another PIL which was
it
disposed
was
of.
the submission made by the other side.
My lords,
They said that there was a PIL,
lordships,
you see, more or less on the similar issue. And
lordships.
it has been disposed of by the division bench. And the order of division bench basically covers the entire issue.
It does not, my lords. There are separate issues over here.
Then we'll have to see that.
My lords.
Then what shall we do?
And if, my lord, we haven't, if the board, Lordship make adjourn for a day, Lordship.
Day means it will go to next.
Next week. What we'll do is, my lords, we'll also have the division bench judgment placed before your lordship, so that
That
things
is what is needed actually.
Lordship.
That is to be decided first.
we'll do that.
But then if it is covered, then there is no.
My lords,
see,
that matter was only with regard to transportation. I am aware of that other matter because I've appeared in that other matter as well.
but then you have seen the order passed in the PI.
My lords, I am aware. It does not cover all the issues here.
Okay, we'll just see.
Because this pertains to certain SOPs which were issued by the government of Meghalaya regarding auction of cattle, my lords. That did not deal with that. That dealt with transportation of cattle.
Yes, you are appearing for? You have anything to say here?
My intention here is only with regard to the land. This particular land has been used to the government.
And what about the PIL? You were a party there.
My learned friend is only with regard to my lords, a certain land was allotted to me which belongs to them, which they had leased out to the government. Now there's some problem between the government and the district council insofar as that land is concerned.
Union is also a party.
I'm for the BSF. Yeah.
What role? They are not discharging their duty properly.
No, they are, my lords. What is happening is BSF is seizing the cattle. Now there are certain guidelines which were originally proposed before the Honorable Supreme Court, my lord. Subsequently, the central government has come up with those notifications.
In the state of Meghalaya, my lords, those guidelines are not being followed. So what has happened? The cattle which is being seized,
Who are the authority who should follow? Who are the authority who should implement that guideline?
the state, my lords.
State, not BSF.
Not BSF. So what is happening? What BSF is seizing, my lords, is again going back into the same smuggling racket.
So state is the main respondent here.
State is the main respondent.
Now you know what is to be defended.
Your Lordship.
So come prepared.
I will.
Just say on the request made in the BF state respondent, it's just matter after a week.
Madam. 7.
Item number 10.
Yes. Washing.
Please, Lordship. Yes.
Ready for the fight. Yes.
No, Your Lordship, what happened here actually, there was a case against me. The FIR has been filed. That is at page 13. The type copy is page 14. So here there is an allegation against the petitioner herein, saying that we have alleging that we try to kidnap the opposite party, saying that
There is a private party also.
yes, private party.
Are they appearing?
They are appearing. Mr. Sheikh is appearing for the private respondent. Just now he was here actually. Yes, the private respondent.
Yes. Yes, go ahead. Go ahead.
Yes, Lordship. Now in the FIR, what is stated, I will just, Lordship, may just read it, Lordship.
Yes. At page 14.
Yes, Lordship, that's type copy. With reference to subject stated above, I would like to submit herein that written first information report to the effect that on 1st 2018, Sri Mithun of Rishu Nogat Court over phone telling that there is a one veterinary garden for selling at Nogat for emergency medical treatment. Accordingly, I come and I met Mithun at Kaldang village, where from Mithun accompanied me to his mother's house at Nogat. After having tea, we left the house of Mithun's mother to see the veterinary garden. As such, I rented my own motorcycle, number AS so and Mithun and Singh San in their bike and proceeded ahead. On reaching at the place in between Nokat and Barka at around 2 p.m., suddenly 3 arms miscreant. One of them is identified as Impu of Bakra had stopped us at gunpoint. Then two armed miscreant had caught me with the help of Singh San and Mithun and taken me possibly into nearby jungle and kept in the jungle. Then two unknown miscreant called my wife, telling that your husband had been abducted and threatening to kill me if not pay their demand of rupees 30 lakh. Somehow, I have managed to escape from the captive on 3rd January 2018 and reach at home safely. This is the allegation against all the petitioner here in Lordship.
You are Mithun?
Yes.
You are Mithun, isn't it?
Yes, Lordship. Here
you are dangerous when you have a gang with you. Huh? You move with the gang, isn't it?
That is the allegation, my lord. Because see here we are before this one Impu and then saying run. Yes. This petitioner actually here Mithun. Here there is no Mithun. Yes, of course they allege. Yes, I'm next part Mithun. Saying run. 3 of them who were alleged in the FIR, we are before this court.
Then what happened?
Then, Your Lordship, during the pendency of the now case was registered, Your Lordship. Then after that, it was they have supplied a copy. It seems that they have filed a charge sheet, Your Lordship. Then, by the meantime, Your Lordship, I would like to draw to the annexure 2, Your Lordship, where the both the parties, actually the complainant, accused as well as the victim, they have made a compromise. Means a compromise that
This case was registered under what section of law?
Lordship, the section is yes, it's quite serious. It's uncompatible.
Charge sheeted case.
Charge sheeted. Now, charge sheet is under what section? Filed under what section? Charge has been framed. Any charge has been framed.
Lordship,
The charge sheet, what I got it from Lordship, it is here. I think this is the charge sheet. It is only one page, Lordship. Me, I just.
Okay. It is under section what section?
364A, Lordship.
Under section 354A, 506, 34 IPC.
364, not 354. 464. 364, Lordship.
Kidnapping, isn't it?
Lordship, kidnapping for ransom, my lord.
Quite serious. And then what happened? Then you have compromised.
Yes, both the accused and also the complainant, the victim, they have compromised, my lord. They have compromised, saying that this victim has filed the complainant without knowing without knowing and ascertaining the accused person. It was filed.
Without knowing ascertaining, that means you were not there. Somebody else.
Yes, as per the statement of the in the compromise, saying that by mistaken, yes, filed it. Now the intention is that they wanted to live in peace. They don't want to take a revenge. They want to pursue. Don't want accused. Don't want to pursue the case.
He wants to live in peace.
I didn't understand that some part, Lordship. Wrongly accused.
Tell us. Definitely, this is a case not compoundable. That is why you have
come before this
compromise.
Lordship.
The compromise. Does it mean that all cases can be compromised?
Yes, Lordship. But one thing,
even a 302 case, can it be compromised?
No, Lordship. I admit, even
there are some judgment by apex court, isn't it?
Yes.
2012, 2019.
Yes.
With regard to compromise, isn't it?
He was supposed
even
to.
Maybe attempt to murder also can be.
If I may, Lordship, he was supposed to bring some judgments.
Yes,
I
brought it,
Which
Lordship.
one?
I have brought it, Lordship. I will supply the old edges.
They've not supplied
I'll
for
give it
time.
Kindly have it.
Yes, complainant, you have compromised. Yes, you are there.
Yes, Lordship.
This is a compromise.
Lordship with the additional Lordship.
Yes.
The other additional.
Even kidnapping case can be compromised.
Lordship. Here in the charge sheet also, my lord, they said in the main accused is still absconding. That means it is found out that.
What is this? You do not have a report.
Actually, if this is how we got it, but
Narinder Singh. Thereafter, after Narinder Singh also there are many
There are
judgments.
many other judgments, Lordship. This is a decade old.
Also, just see there is a judgment.
More than a decade old judgment.
But then, Lordship, but this order, this judgment have not been, as far my knowledge,
But then does it say that even these heinous crimes can be? I don't think. They cannot compromise. What is the punishment in 364, madam?
364, my lord. Punishable with death or imprisonment for life, and shall also be liable to fine.
Cannot be compromised. Just see, probably see. You go down there to the lower court, convince the prosecutor, and seek withdrawal from prosecution under 321 CRPC. That will be better. You can go through her. What is the citation of this Narinder Singh case?
My lord, I like to rely on the para 11, 12, 28, 29, 31 and 35, my lord.
So many paragraphs.
Mainly I rely on the 28, 29, 31 and 35, lord, my lord. Just may I read your lordship the page 28 and 29 and also 31 and 35.
Before that, let us see what you have written in your compromise.
Your lordship.
Come to your compromise. See, this decision is reported in SCC also, Mr. Sangma. Why don't you get the citation of the SCC?
Yes, Lordship, if that is the case, I maybe give it some time. I will just get a correct the SCC because
That
I
is
just
that will be most
yes,
convenient
yes,
for us,
yes,
for
yes,
everyone.
yes. Because this what just we get it from the net, but I will give the proper judgment, Lordship, and Xerox and give it to Lordship on the next date, Lordship. And I will see also some other judgment. As of now, I have this one to rely on my case.
What your compromise is?
My compromise is the relevant part. Your Lordship, it is there in the.
How many accused are there in this case?
In this case, actually, here
As
we
per
are.
the charge sheet, how many accused are there?
Lordship. There are 1, 2, Lordship. I think more than
No.
4 or 5.
No, there is only
There's
3,
the
4.
petitioner. Then there's one MPCH moment.
The petitioner info, the three accused persons before this court. That one accused person, Lordship. There are actually, as per this charge sheet, there are 4. 3 before this honorable court.
So it means the charge sheet has been filing it 4 accused.
4 accused, but one still not have been arrested as per this charge
Anyway,
sheet.
but then there is no compromise with the 4th accused.
Lordship.
Now what happens if we allow this compromise application? Then what happens to the fate of the other accused? What happens to the fate of the case?
Naturally, Lordship.
Say in a case.
Yes. If
Just
this
we have
is
to
allowed.
reply. See, in a case, just hold on for a minute. In a case where there are several accused, can it be partly compromised?
No.
By, say, 1 or 2 of the accused, and the half remains for proceeding.
As per the criminal law, actually, there cannot be part half compromise, because here only after the investigation on the FIR, the main accused they have not mentioned, but it is only after the charge sheet we come to know that there is another accused who is also absconding. If that is the case, that we
But the charge sheet is against him.
Charge is against
He is
him.
absconding.
He is absconding.
So until and unless that case is segregated, like what happened in that Rajiv Gandhi's case, assassination case.
Yes.
You hold separate trial. It is segregated. Can this compromise be acted upon?
No, Lordship. I humbly say
Things are becoming more complicated. You have to answer all those things.
Lordship, basically, as Lordship has found out, we have to file an application to segregate the case between.
That we do not know. That is what has to be done in the trial court. It's not before here. But then there exists a provision in CRPC. Maybe you will get in some part from 220 or maybe 200 something plus or what. Just will find it. That is there. But then the thing is that what would be the effect of this sort of compromise? By say not by the compromise is not entered into by all the accused, only by some of the accused. Then how can it be acted upon?
Actually, Lordship, this the trial actually once the evidence taken that this my accused can
show
be
us some law. You show us some law that it can be done. It can be partly compromised.
As far as of course, I admit that partly compromise cannot be done because it will have a effect on the bearing effect on the other accused, the main accused who has not come before this court, and the victim also have not compromised with that.
No, then you compromise it, and it may say main accused is caught, and therefore trial proceeds. And the trial, it is found that you are involved. Then can again 319 be resorted to?
Lordship, I will get the instruction. If
you do not have to take instruction,
Lordship,
that is for you
now,
to answer.
Now I will go through all this angle. If required, then I may withdraw the petition and may some other I may relieve.
Definitely, you see, say supposing there is a, you see, like coming and seeking quashing is not the only option.
That's true.
You may explore some of the other side also. Sometimes it happens if the proceeding before the trial court does not serve any purpose, then prosecution also sometimes withdraws from prosecution. There is a provision provided in CRPC for that also.
Yes, Lordship.
Here only the prosecutor has to be convinced and thereafter permission has to be sought from. That is what the law is. Of course, we do not know. That is for you to decide. Okay. Now, as has been pointed out by the senior GA here, that there are more than 3 accused, more than the number of accused who have entered the agreement, then it becomes difficult for the court.
Yes. Yes.
Because unless you show us something, this court will not be inclined to interfere.
The only, Lordship, I admit, but only problem is because while filing the compromise and this one, even victim was not aware of the other accused who is still absconding. That's the reason why.
That is okay, but then you cannot speak on behalf of the victim. This
Yes.
is for Mr. Sheikh to say. Is it correct, Mr.? You do not know.
Yes, Mr. Sheikh will say.
If you
Well, since the fourth accused person is absconding, Lordship, let them find him out and the police will take.
No, we are not absconding. 3 of us, we are not absconding. We are appearing before the court. Only one accused who is named in the charge sheet. Since as per the charge sheet, he is the main accused. And police have not able to trace till date also. And interestingly, the main accused was not named in the FIR. The accused person, we have come, the petitioner hearing, main allegation is against those who has come before this court. They have mentioned 3 names. 3 names are all the accused persons who are before this court. 3 names in the FIR. It is there in the record. But however, during the investigation, it's come to be the other main accused is not this 3 person.
That means the leader of your group
Exactly.
was not named.
He was not named.
You were soldiers. The commander were not there.
Mithun is not the leader.
Anyway, you just find out some decision.
Lordship, some decision if required to be, then I will take the
find out
appropriate.
now. This not only this thing. This is Narendra Singh case. You see that aspect. Where
Lordship.
there are several accused.
Lordship.
Can it be compromised on behalf of certain accused and others be made to face the trial?
My lord, exactly. I will try to assist, Lordship. I try to find out.
You will have to assist.
Lordship.
This court does not know anything. So if you do
Exactly.
not give assistance, then it will be difficult.
I bow down, my lord.
Much
When
better.
you will do it?
Let it be come after 2 weeks if my friends have no objection. After 2-3 weeks,
We are friends, no objection, much.
it come later after 3 weeks. Because we need some research, Lordship.
You said 2 weeks and now you are saying
Lordship,
that
yes.
3 weeks.
Lordship,
When I
after
agree,
2
then he
weeks.
said 3
Once he
weeks.
says that he has no objection. we say
Exactly. Taking advantage of friendship, my lord.
Okay, just on the
My lord, I have not taken advantage after all.
Much obliged, Lordship.
Lordship.
list of references.
Second call, item number 2.
Much less, Lord.
There was an unlisted motion. Is it? This come. Yes, this hearing will take some time.
Will take some time.
Then we'll have some one unlisted motion is there. Let us, Mr. Paul. There is one unlisted motion. So if your matter takes some time, then we'll just.
I had a very limited prayer. I don't think it will not take too long. Well, it's, this matter your lordships have seen. This is that where, my lords, we had asked for recalling that order and allowing us to adduce further evidence insofar as plea of alibi was concerned.
Probably you have to refresh the court, man.
My lords would want to take the unlisted first, my lords. No difficulty.
No, there is not this thing. So if your matter is short, then we will listen.
My lords, I have a limited prayer. What I was submitting before your lordships is, my lords, that the law is very clear, my lords. I can go back and make another application before the learned district judge there, sessions court there. If only that limited liberty is granted to me, my lords, because as your lordships had indicated also
What
last
is the
time.
matter about? Tell us.
Well, what had happened is in this, there was a trial. And after substantial delay, my lords, there was an application filed by us for recalling certain witnesses with regard to the plea of alibi. Learned trial court, my lords, while recording everything only on the, largely on that issue of delay, says that at this belated stage, we cannot file that application. Only on that limited.
What is the order of the trial court?
Page. At page 73, my lords, Annexure G, page 73.
You're reading from there.
It appears to be a long order, quite a long
It's
order.
a very long order, my lords, page 90. Paragraph 9.9, if your lordships have it, my lords.
This is a 2015 case.
My lords.
Second case is of 2015.
My lords. The plea of alibi has been taken by the accused and there is no whisper of alibi in the evidence of the DWs. Cross-examination is sought of the PWs on the ground of deficiency by the conducting counsel in the cross-examination. Prayer has been made successively on the same ground. The accused is praying for recalling a witness PW 1 and 2, 3, 5, examined on 15, PW 2 examined on 15, well, it's examined on 15, PW 5 examined 15. After a lapse of almost 8 years, prayer has been made for recalling the witnesses for re-examining the intervening period. What has transpired, as has been discussed above, this court cannot lose sight of the fact that this is a case involving serious offence. PW1 is the eyewitness. Delay in trial not only erodes the evidence but also the memory gets faded. Any diabolic attempt to prolong the proceeding would only give a leeway to exaggerate the truth. The witness who have been examined during trial can only be allowed to re-examine if it is indispensable for just and proper disposal of the case, irrespective of the prosecution or the defense case. The power under 311 of the CRPC has to be exercised only to subserve the cause of justice and the public interest. Finding out truth from the just decision is indispensable in criminal trial. However, the journey has to be on the procedure prescribed by law. The checkered facts of the accused case reveals that there are glaring materials on record to manifest that after examining of 313 of zone, he had sufficient opportunity to take corrective steps under proper guidance. However, he had chosen only to express his ignorance of his right. After a lapse of almost 7 years, on being aware of his rights to defense properly, the accused had chosen to repeatedly exert his right, which amounts to abuse of the process of the court. It is a case, on one hand, the accused claims not being aware of his right, and on the other hand, being aware of his rights, he had chosen to abuse the process of the court by filing successive applications on the same ground. Application of this nature needs to be deterred for such reasons discussed above. I'm sorry, Mills.
There, you see, like this order says that you have suppressed also the facts.
But which is why I say I'm not pressing this application before your lordships. Your lordships, I had argued this matter at some length. I have examined this matter.
This court will not give you liberty. You see, you have to answer. You see, normally the finding of facts.
My lords.
Recorded by the trial.
My lords.
Until and unless it is not based on any existing things, we will not interpret. There is no question of.
No, I am not pressing for this matter, my lords, in the first place.
It seems it appears that there are some adverse findings against you.
The adverse finding is, my lords.
You say on close scrutiny of the application, the accused had suppressed the facts and duly closed by so and so, so and so. See,
Your lordships are referring to.
Even if it goes to saying that you have obtained some order from High Court by suppressing those. See, anyway, then we'll be needing a detailed hearing. You say like.
Well, lords, as your lordships may feel.
So if you want to proceed, we'll proceed then. There is no problem.
Then we can have it some other day, my lords. As your lordships will feel. Then we will go in for the full hearing. What I saw, my lords, is that the averments in the revision petition are a little.
This is a case which was argued by a counsel from Guwahati before.
Yes, my lord. Ms. Goel.
You've been so probably you see.
My lords.
Now probably this court recollects.
After that, my lords, your lordships had heard me also at length.
The time when the argument was taken by the counsel from Guwahati.
My lords.
Those things were, you see, like. Put before her.
My lords.
Then the reaction of the council that she will bring some materials to refute the allegation.
My lords, that has been done by filing an additional affidavit.
No, but then you have filed an additional affidavit to bring in the certified copy of the judgment or
no? No, there's a thick additional affidavit that has been filed. This was filed on the 20th of November 2023. I think that leave was granted by your lordships, my lords.
My lord, the subject matter itself is very clear, my lord. An affidavit bringing on record the certified copy of the impugned judgment and order dated 26/2023.
Which is your affidavit, the first page?
Just a second.
That is what you say.
That one page is missing, page 1. Can I just borrow it?
Anyway, just we'll see.
No, no, it says only judgment, but the
We go by what you say.
My lords, there are essentially, my lords, 15 documents which have been filed. The entire proceedings, including the evidence of certain persons, have been brought on record.
Anyway, let us see. Let us see.
Because when I examined it, my lords, I am on a very short compass. I cannot go.
Finding of facts.
My lords. My lords, the only issue here is that for the proper, my lords, for any court to take out the truth in respect of a criminal trial, my lords, the aspect is, it is a 302 matter. Now, the punishment on the 302, my lords, is the gravest of the punishment.
That is
Now,
all right. That is all
whether,
right.
my lords, whether delay would defeat, my lord, the fact that, my lord, somebody wants to examine a witness only at the stage at the fag end of the trial, only for the purposes of, my lords, taking out the truth. That is the limit to it.
There is a procedure prescribed by law.
That is, my lords.
For rendering justice, we have to go by the procedure.
Absolutely, my lords. I bow
You
down.
cannot substitute it.
No, I bow down, my lords. I bow down. Only issue is, well, is that this application was filed at a belated stage. After 8 years.
Apart from that,
It's not only, there are repeated applications.
yes, my lord.
You came to High Court also before.
Yes, my lord.
High Court?
Yes.
Not on this issue, my lords. Not on this issue.
Why not? There cannot be at the same instance. You should have.
What I'll do
made
is, my lords, I'll prepare the matter properly. I'll try and assist your lordship. But not, as far as I am aware, my lords, on this issue, we will not come before the High Court.
My lord, there are 8 accused altogether, my lord, in this case. Now, my lord, only because of this particular accused, my lord, the trial is stalled, my lord.
How is it?
Why it is stalled?
Because it is.
There is no interim order by this court.
No,
the
my
matter is to be finally heard, my lord.
It has been heard. As a matter of fact,
It has been heard.
the hearings is continuing, my lords. The hearing is continuing. There is no interim orders passed by this honorable court.
We'll just see, because there is the order says something about the conduct of the accused.
My lord.
We'll just see, we'll scrutinize it.
My
If
lord.
we find that it is correct, whatever has been recorded, we'll throw their application.
My lord.
Because, my lords, the other aspect is successive applications is not barred. The law is very well settled on this, my lords. We had produced the 2 judgments of the apex court, my lords, on this issue. That successive applications on this issue is not barred by law.
That is all right. But then you see.
But my conduct, your lordships are right. It cannot be, my lords, that if there's suppression on my part, my lords, obviously your lordships will not interfere. That I will have to satisfy your lordships. I'll make an effort to satisfy your lordships. Sometime next week, my lords, would it be convenient to your lordships?
My lord, next week I may not be available, my lord. So thereafter, a week thereafter.
First week of June, my lords.
Today is what date?
Today is, my lords, the 15th.
15th.
So if you say after 2 weeks, this will be more or less all right.
First week of June, my lords.
Then it has to go after 3 weeks.
Only, my lords, my learned friend has a difficulty next week. And from 27th to 30th, my lords, I am not.
You will have a difficulty.
I am not in station, my lords.
That's no news. This court was on the other side for many years, so we understand how difficulty arises. We'll have it after 3 weeks then.
My lords, grateful.
Just on the request made by the parties. Just after 3 weeks.
Yes.
Supplementary cause list, item number 1.
Yes, what is the urgency?
My lord, this is a classic case, my
You were
lord.
here from yesterday, isn't it?
My lord, this is
Maybe
a classic case.
mentioned the wrong time yesterday.
My lord, I am extremely sorry, my lord.
Yes.
This is a classic case, my lord, where DGP of Meghalaya is challenging the action taken by his own police personnel, your lordship. Your lordship, I am taking your lordship straightway to the FIR, my lord. And my lord may kindly come to page 25, your lordship. And relevant page starts from 27.
Yes.
May I read your lordship? Subject: misuse and tampering of registration number of the vehicle in use of Sri so-and-so, the Director General of Meghalaya. I have the honor to bring to your kind notice that the inquiry committee constituted so-and-so submitted, he is saying about some inquiry, my lord. So-and-so Varna, which is parked at Central Workshop, has been allotted a fake number so-and-so. Your lordship may skip over. As per letter under right to information, so-and-so about the said vehicle is registered with Transport Department, Government of Meghalaya as ML so-and-so in the name of Director General of Police Meghalaya, Shillong. Thereafter, the aforesaid information under the RTI by the Transport Department, Government of Meghalaya nails down the said report of the inquiry committee, which calls for necessary action against the members of the committee. I am pausing for a moment, your lordship. He is saying about one inquiry committee. This is confidential document, that's why I have not annexed. I will place before your lordship. Inquiry was conducted against the informant who is under suspension, your lordship. facing.
He refers to
One
an inquiry which was against him.
Against him,
the
Your
complaint.
my lord.
And now he says that in that inquiry committee report, like some sort of
And action should be taken against the members of the inquiry committee. That I will place, my lord, inquiry committee.
you are what? You are not a part of the inquiry?
No, my five senior police officers are the part of that inquiry committee, my lord.
Now this FIR is about what? This speaks about
Using, my lord, number plate of Meghalaya by Director General of Police, my lord, because of, my lord, special advisory issued by special branch, my lord, because of security purpose, my lord.
that is all right. We will not just let us not go.
This is
your explanation to the allegation. You give it later.
My lord.
Just tell what the FIR says.
FIR is this, that I have used in Assam number vehicle, Meghalaya number, in discharge of my official duty. This is the allegation.
Yes.
And I am using highly value vehicle.
Now, say supposing if it is inquired into, what is the problem?
My lord, because the
truth will come out.
What I am submitting, my lord, this person against whom, my lord, one inquiry was conducted, charge sheet has been filed, my lord, against this person. 10 charge sheets. I'm just coming, your lordship. So far as this, my lord, sections which has been leveled against me, my lord, section 409, 467, 471, 192 of Motor Vehicle Act, those ingredients of those sections are not attracted at all, my lord. Even assuming, my lord, the number plates have been used for the security purposes, the notification I will place, my lord. In that case, 192, 5,000 fine is there, my lord. But because of non-billable sections are being, my lord, I have been humiliated by media, my lord, in my community itself, my lord. It is not that, my lord, if, my lord, something is there, my lord, I am ready to face. My lord, number plate, or that is used by office, your lordship. Because of the internal SB report, that your lordship will see. And
No, this case has been registered. This FIR
registered under section 47, my lord, the sections ingredients are totally absent, my lord. What I have misappropriated, my lord, nothing. I will show, my lord, Bhajan Lal, Lalita Kumari, what it says, my lord. If the cognizable offence is made out, in that case, my lord, FIR can be registered. No offence has been made out, my lord, on the face of it. Being a head, my lord.
Which part will be relevant?
Relevant, my lord, your lordship will see this one letter first, Office of the Additional Director General.
Yes.
Information, my lord, your lordship, information on incident of vehicles with Assam registration numbers. There have been, my lord, it says, my lord, I am not reading, your lordship.
Yes, sir.
My lord. And other documents are also with special branch, your lordship.
You are not giving me copy?
And
this speaks about the
other documents are also with special branch.
See, it did not say that this thing number plate should be replaced.
My lord,
it says you avoid using outside registration vehicle.
My lord,
that is what.
My lord, this vehicle was requisitioned by the state government and bearing Assam number, your lordship. And office has, because of other internal report from SB, if your lordship call for records, there is, my lord, because of the incident, because, my lord, more than
there
5
is a specific order,
my lord, there
allowing
are
you to change.
There are
that. Where is that order?
My lord, that I can't. This is a special branch. It is.
But then this is also a confidential.
This was because it was communicated to me. This letter. Others letter are there. They, in fact, it was done not by me, your lordship. What advantage I have taken, my lord? Nothing, my lord. By using no misappropriation, nothing, your lordship.
That is okay.
My lord, and your lordship will see this person, my lord. Inquiry report I have given, your lordship.
Yes.
Allegations.
He refers to this inquiry in his
Yes,
affair.
this inquiry, my lord.
Yes.
My lord, it is AIG, and he was AIG. Last but one paragraph, my lord. During inquiry, it is ascertained that almost all newly procured vehicles, irrespective of who is not sanctioned for.
You are reading which part?
First page, bottom B, clause B, your lordship.
Yes.
During the inquiry, it was ascertained that almost all newly procured vehicles, irrespective of who it was sanctioned for, were utilized by AIG, who is the complainant, my lord. This is evident from the letters of handing over the vehicles made by so and so. Thereafter, my lord, next page, your lord, a total of 31 vehicles were in the personal custody of AIG without any sanction from competent authority. Some of the vehicles had no registration plates while they were used, and no logbooks were maintained. Thereafter, my lord, I am just showing, my lord, misappropriation part. My lord, page 4. Page 4, clause C. 3 crore 35 lakhs, it was misappropriated by him, my lord.
But that is all right.
Why? Because of the personal, my lord, grudge, your lordship. That's why Bhajanlal says, my lord, this FIR.
But then you are not a part of an inquiry.
I am not. The inquiry was conducted by 5 members.
Then if he has personal grudge against the inquiry.
But he is writing about me so far as numbers are concerned, my lord.
Just hold on.
I am sorry. I am extremely sorry.
Court has not taken any view. It's only query.
I am extremely obliged.
So even if court asks anything,
my lord, absolutely, my lord. And it's pleasure, my lord. I am arguing.
You think it's going against you,
my lord.
Just for the timing, do
my
not.
Lord, first time I am arguing before your lordship.
If you say that this is vindictive action, in such a case, this FIR should have been against those persons who are the part of the committee, isn't it?
He has written it, my lord, to take action. My lord, page 25, your lordship will see. And page 27 at the bottom. He has not named, but he has the aforesaid inform, page 27. Under the RTI by the Transport Department, Government of Meghalaya, nails down the said report of the inquiry committee, which calls for necessary action against the member of the committee. Members. And during my tenure, my lord, charge sheet has been filed in altogether 8 cases against him. He is now at present under suspension, my lord. Everything has been done during my career, tenure, your lordship. Now, because of that, your lordship, this, my lord, FIR, which does not disclose any offence, my lord.
What is the ground you have taken in this
my lord, ground, my lord, the ingredients of sections that your lordship will see.
That may be quite difficult in 482 application.
My lord. And
whether there is a disclosure of offence or not, that can be a ground.
My lord.
Anyway.
And number 2, if even assuming 192 motor vehicle here, it says, my lord, non-registration of vehicle. For that, my lord, 5,000 fine is there. That I have memorandum. I am annexed page 33.
No, what you are praying here?
Praying for quashing of FIR
at this stage.
My lord.
At this stage, what is your prayer?
At this is staying the proceeding, your lordship.
Saying the proceeding.
My lord. Big embarrassment, my lord.
If inquiry goes on without any coercive action against you, then what is the problem? Say supposing that court doesn't stay the inquiry. Say let the inquiry. Let the truthfulness of the allegation be determined. But then court restrains them to take any coercive action.
My lord, I am obliged.
That will.
My lord, I understand, my lord.
Yes, Mr. Sulai.
I am obliged.
Lordship, in my humble submission, Your Lordship, there is an FIR. The informant is required to be heard, Your Lordship. Let notice be.
That is okay, but then you have registered a case. It just doesn't mean that informant will come anything and will register. You must take a stand. And what is
Lordship,
there
let me
is
have
FIR.
instructions. So
If
far,
if a person is supposed to use a vehicle of certain range, you see, it's to be alerted by the office and all. If allegation that he has used something higher than that,
whether that is an offence or not, let me
criminal offense, you take departmental action against him, departmental things and all.
let me have instruction, Your Lordship.
Okay, hard, Mr. So-and-so.
A Goyal.
This court is very poor in remembering names.
My lord. It's my pleasure, my lord. First time I was waiting to appear before your lordship, and I got opportunity to appear, my lord, before your lordship. First time, your lordship.
So issue notice, returnable in 3 weeks. Mr. LD Shulai appears
R1, Your Lordship.
for respondent number 1. And such no formal notice is called for with regard to the said respondent. However, petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. Hard learned counsels for the parties on interim prayer. You can sit down. It's my. A DGP has the fear of being, you see, fear of his own force.
Classic, my lord.
We'll do one thing. We'll pass the protection till the returnable date because private respondent is yet to appear. Okay, so without giving a reason or
No coercive action, Your Lordship.
because
No
if we
coercive
do
action.
that, then he may have a chance to, you see, like raise his grievances. Okay, just only do not say hard these things. Just say at the interim, it is directed that no coercive action be taken against the petitioner. Till the returnable date. No coercive against taken against the petitioner in Sadar PS case number so and so 141/2014. Under section, just you copy it from the petition till the returnable date. Okay, that will serve your purpose. We'll just see. It appears that yes, definitely, but then even then, you see, if fire discloses some offence,
In that case,
it fulfills ingredients of certain provisions or not. That is not the criteria.
If other offence, if other offence is also disclosed, in that case also, my lord, I can understand.
Because
But
otherwise, you see, like always, there is this allegation can be, you see, like sorry, the sections can be changed.
It can be changed.
So, what is important?
If it discloses
that there is
any
only
offence.
disclosure of offence or not.
In fact, my lord, a bare reading of that, my lord, it doesn't disclose any of it.
It appears to be some sort of vindictive action, but then that is a prima facie view. That
Prima facie.
and we cannot condemn the
Until unless he's heard.
So we'll just protect you till the next date, and then we'll just say. You do one thing. This before this part, you just said this is an application under section 482 CRPC. Because you see, like when there are people big, involving big people, even for small thing also, the court has to be careful in person. This is an application of 482 seeking quashing of. So that PS FIR number 141 within bracket 5 2024 under section 409, 467, 471, 120 IPSC. Stop. The prime contention raised by the petitioner is that decide FIR has been filed by the respondent number 2 to seek revenge against him. Mainly due to the institution of some inquiry against him during the tenure of the petitioner as DGP of the Meghalaya Police. It is also contended by the petitioner that the offence disclosed in the FIR dated 9/5/2024. What is it? What is it? It is do not constitute any offence under which the case has been registered by the police. Mr. Andy Shulai Ranade AG appearing for the state. 6. Time for praise for time, grant of time for seeking instruction in the matter. You just say prayer aloud. Then you say at the interim, it is provided that no coercive action be taken against the petitioner till the returnable date. No coercive action should be taken against the petitioner in the matter till the returnable date. Then list after 3 weeks.
Apply and answer.
Deeply obliged.
Daily costless. Item number 7.
You not like to take back your inquiry report, or you want it? If you say it is confidential, then it is better.
Deeply.
May it please your lordship.
Yes.
Lordship, I'm seeking for some accommodation in this matter. Senior conducting counsel is on legs.
Right from the morning till now, you were accommodated. Now it is your time to act.
Lordship, I'm praying if this matter may be listed. After
Yes, you are ready.
I'm only the performer responding, Your Lordship.
You are the performer respondent. Who are the main respondent?
The state, Your Lordship.
State. Who is appearing state for state? None appears for the state. Yes, you are for the
Sorry,
state.
my lord. Yes, my lord.
You are ready.
Yes.
She is ready to argue. We'll take up. Yes.
Lordship.
Say yes. At least tell about the case.
Lordship.
What is the difficulty? What difficulty you have?
Lordship.
Why you are seeking adjournment?
Lordship, I have very limited instructions, Lordship, in this matter.
Valid instruction means this is at the stage of filing hearing. One instruction you want to have. Actually, limited instruction with regard to taking up the matter.
Lordship,
Then, what is your instruction? What is your limited instruction?
Lordship, to have this matter.
To have this matter adjourned. On what ground?
Lordship, Senior Conducting Counsel is on legs, Lordship.
Can it be ground for adjournment? Yes.
My lord, this relates to the removal of signboards, my lord. And on the last occasion when it was heard, my lord had put a query whether these members of, regarding the members of the association, my lord.
Okay, yes. This is by an association.
Association,
where
my
they have
lord. Who are
challenged the
the
removal order of removal of the hoardings.
Yes, my lord. And according to
Yes,
the
yes.
affidavit which we filed, we said that we had filed under the compliance of the Supreme Court's guidelines and orders.
Yes, yes.
So we have started to remove all the signboards, and they were aggrieved by that action.
Now this court remembers. It was hard also at
Yes,
some
ma'am.
length.
Yes,
And it was found that the permission, the period for which the permission was given, in some cases it has expired.
Expired.
Has not been renewed. And it appears that for different members or maybe different persons, they are different.
Yes,
and
ma'am.
there is no
Different
disclosure
authorities.
disclosure or details of the
No,
members.
nothing was
How
given.
many members and all those.
No, my lord.
Yes.
Lordship, with regard to the number of members in the association, we've actually tried to contact, but we've received an invalid number so far, Lordship.
You have not received.
No, instructions on that
No, see,
aspect.
it's
also,
not only the numbers, it is the members. Then you have to see the impugned orders you have annexed with the petition,
Lordship.
whether that relate to those members or not. And you see, like by association, if different individual has cause of action arising on different occasion, then what would be the thing? That also has to be seen.
Lordship.
Anyway, when do you want it?
Lordship, next week.
You say next week and you never take up next week. That is a problem.
Definitely, Lordship, next week.
And see if that's whether the cause of action still survives or not, because this is old matter, 2017 matter, and fact remains that these boards are already removed.
Already removed. There was
Now,
no
can
stay
this
order.
Can this thing be removal be revived?
Lordship, essentially the primary contention in our case is that it's not just the removal or removal of these signages or hoardings, it's also that there's an absence of policy. So the amount that has been paid.
You have taken benefit of whatever the thing is. Without there being a policy, you were given those contract
Lordship,
or the permissions.
Lordship,
Now,
and
at the timing of taking permission, you did not allege that no, there is no policy. So long a thing goes to your advantage, you will not challenge it. Moment goes to your disadvantage, you will come and challenge it. Can we basis? You find this code very discouraging, isn't it?
no, Lordship.
On the request made on behalf of the petitioner, this is matter after 2 weeks.
Highly obliged, Lordship.
Make sure these matters will not give you much time next time, next occasion.
Lordship.
Do not compel the court to become harsh.
Lordship.
You see, the court also doesn't get pleasure by becoming harsh or behaving harsh with it. But then at least some work should be done, isn't it?
Yes.
Nothing more.